So welcome, Edward, Vivian, and Thea, and whoever will be joining us tonight, especially those who will be viewing the recording. So tonight, we will be discussing the topic on legislative scope and purpose. And at the end of the topic, you should be able to discuss and explain the 3 key rules that a decision maker must observe in making a decision or in exercising a statutory power. Namely, a decision maker must exercise a statutory power according to the purpose for which it was conferred. Secondly, in exercising a statutory power, a decision maker must not take into account irrelevant considerations. And thirdly, in exercising a statutory power, a decision maker must take relevant matters into account. So, especially in relation to the way that statutory power must be exercised by a decision maker, I recall an important case in Australia involving the case of an Indian doctor whose name was Hanif. Just to show you how important administrative law is. And in that particular case of Dr. Hanif, he had been working in Australia for a few months on a 457 visa, which is a temporary work visa. And because he had some Indian family in the UK, he sent money to them, and at the same time, he even lent. At one point, he had actually lived in the UK and actually lent his SIM card for the phone to somebody in the UK who was a family member. As it happened, one of those family members was involved in a terrorist activity in the UK, probably around 1997. So this is probably familiar to Edward. I can't remember which bombing it was, but it was a bombing that happened in the UK. And 2 of the terrorists, if you call them terrorists at the time, were actually family members, or those related to Dr. Hanif. And as a result, when immediately after the bombing, what had happened was that Dr. Hanif attempted to go to India. But a day or 2 after the bombing, he was about to go to India, to return to India. And at the airport, he was stopped from leaving Brisbane in particular and detained. What had made it a very controversial case around 1996 was that Dr. Hanif was actually detained without charges for several days. He was actually put in solitary confinement, and he was not given access to counsel. And so that brought issues about human rights violations. And the reason why he had been detained by the Australian Federal Police was that there is an Australian federal law pertaining to crimes involving terrorism, where somebody can be arrested or detained on the basis of an association with somebody who has been involved with terrorist activities. So the word association was loosely used by the Minister for Immigration to assert, as well as with the police, initially to assert that Dr. Hanif was actually associated with the terrorists in the UK because they were family members. 2, he had actually given money to them. And thirdly, it would seem that he had lent his SIM card to one of the terrorists. And that SIM card had been found, according to the Australian Federal Police, in one of the cars that had exploded in the bombing in the UK, which turned out later on to actually be false. But he had been, imprisoned for a while. And the question at that point was, when the decision maker it could be argued that when the Minister for Immigration, for example, exercised his discretion, although he had a discretion pertaining to the revocation of visitor visas or the revocation of non-permanent visas, or he had the discretion as to whether or not to cancel visas given to non-Australian citizens. The idea was that he was going to exercise his discretion according to the statutory power given to him under the Immigration Act. And there was an assertion that he was not exercising his discretion according to the law. And so this particular case is an example of how it is important for us to understand in administrative law how decision makers must make decisions on the basis of the legislative scope and purpose. So I'm just giving that as a backdrop. And we can revisit that case in the course of tonight's tutorial. So having said that, let's examine at least 3 discussion questions. There is a 3rd discussion question which I formulated today because I realized that there were only 2 discussion questions, and it might be good to dig deeper into the administrative law topics by coming up with a 3rd problem-based question. So let's be now. Will there be any questions or concerns or issues that you'd like to raise in the meantime before we start taking up these discussion questions or comments? If there are none, then we could probably proceed by going through the discussion questions. Can I ask someone to read discussion 20 for us? Volunteers?
Okay, I will, Manjo.
Thank you.
Okay, discussion question 20. The Commonwealth Development Authority Act authorised the Commonwealth Development Authority to compulsorily purchase or acquire any land necessary to meet the infrastructure needs for new roads and highways of the Commonwealth. At the CDA's Executive Committee meeting on 16th May 2013, the CDA's Chief Executive Officer proposed the purchase of a sizable property along Benwick Road that was close to an area where a multi-billion-dollar commercial complex was being developed. He noted that the Benwick Road property is likely to appreciate in value as a result of the commercial development going on in the area. The proposal was approved by the CDA Executive Committee. In June 2013, Greg Harrison received a letter from the CDA stating that it was commencing negotiations with him for the purchase and acquisition of his property along Benwick Road, as authorised by the Commonwealth Development Authority Act, Commonwealth. Greg does not wish to sell his property and has come to see you as a solicitor for advice. He brought with him a copy of the 16 May 2013 Executive Committee meeting of the CDA. Advise Greg whether there are strong legal grounds to oppose CDA's offer to purchase.
Thank you. Thank you, Anthea. Any volunteers? What would you advise Greg? Is there a way for him, so he doesn't want to sell the property, would there be a ground for him, or a strong legal ground for him to oppose CDA's offer to purchase?
Hi. I thought that he probably didn't have a strong case to oppose this because there's nothing in the question which suggests that this was an ulterior motive to acquire the land. Mm-hmm. And I would think because of what they do, building roads, they're probably going to use the land for road construction anyway. So the value of the land increasing wouldn't be relevant to them anyway. Mm. So it just seems that it was sort of a passing comment that the land was going to go up in value.
Okay. Thank you, Edward. What does Vivian think, or Anthea?
This seems more like a constitutional law question.
Is it? Okay, go ahead.
Well, when the Commonwealth is going to compulsorily purchase or acquire any land, that comes under the just terms section. Is it like section 122 or something? Mm-hmm. So, okay. You know, I think that like when you're referring to the three rules, like wouldn't it be the third one, that in exercising his statutory power, which is the committee, they have to take relevant matters into account?
Mm.
So the relevant matter is that it's his property.
Mm.
So I think then you've got the Constitution has to apply in that on just terms and compensate him accordingly.
Okay.
I don't know. That's my take on that.
Okay. I'd like to ask a corollary question to that. So if you were the lawyer who was approached by Greg, for example, and you wanted to oppose the CDA's offer to purchase, and you wanted to question the legality or constitutionality of the Commonwealth Development Authority Act, can that be a ground for you to raise in applying for administrative review, perhaps in the Administrative Appeals Tribunal, assuming that this particular law authorized an application for review by the AAT? So let me repeat, assuming that the Commonwealth Development Authority Act provides that an application for review can be made to the AAT on the basis of a decision that on the basis of any decision made by the Commonwealth Development Authority under the Commonwealth Development Authority Act, assuming there is that recourse to the AAT, can one of the grounds for application for review with the AAT be on the basis that the Commonwealth Development Authority Act is unconstitutional? Let's just deal with that question for now, and then we'll go back to the answer of Anthea and Edward, and then we'll go to Vivian.
Sorry, what was that second question again?
So the question really is, assuming that there is a recourse to the AAT, the question is, can Greg apply for a review of the decision of the CDA, and in doing so, ask the AAT to rule on the constitutionality of the Commonwealth Development Authority Act?
Yeah, I think yes, provided that all the requirements are met in order to be able to apply for review.
Mm-hmm.
So he has standing. There's been a decision based on an enactment. I can't remember what the other criteria are.
Okay. So the answer there actually is that the Administrative Appeals Tribunal has no authority to rule on the constitutionality of any law passed by the Commonwealth Parliament, because only the courts have the power to rule on the constitutionality of any law. Now, whilst the AAT may actually consider the legality of a legislation for the purpose of reviewing a decision of an administrative decision maker, it cannot invalidate the law passed by the Commonwealth Parliament. It has no power to invalidate a law. Certainly, though, the Administrative Appeals Tribunal can examine the legality of a decision according to the law, but the law itself cannot be impugned before the Administrative Appeals Tribunal. That can only be done in a proper review to be made, questioning the constitutionality of a law before the regular courts and not the Administrative Appeals Tribunal. So I raised the point because Anthea had earlier said that there seems to be a constitutional law component to this. And I found it perhaps necessary to try to determine, where do you draw the line? So when you apply for an application for merits review before the AAT, are you actually permitted to question the constitutionality of a law passed by the Parliament? The answer is no. You can question the legality of a regulation passed by the executive on the basis of a primary legislation, such as the law passed by the Commonwealth Parliament, but you cannot question before the Administrative Appeals Tribunal the validity or legality or constitutionality of a law passed by the Commonwealth Parliament. So I'm just clarifying that. Now, I think, Vivian, you had something to say in relation to this question. And then you have to unmute yourself, then we'll go back to the answer of Edward.
Oh, okay, yes. And Okay, so for me, I'll advise Greg that he has strong legal grounds to oppose the CDA's offer to purchase his land.
Mm-hmm.
And my reason is this: a fundamental principle of common law is the principle of legality.
Mm-hmm.
The government may only act if authorized by law.
Mm-hmm.
As a corollary, individuals may lawfully do anything that is not prohibited by law.
Mm-hmm.
Lord Chief Justice Camden's statement in Entic versus Carrington, 1765, 19 STTR 1030 is the foundational statement of the common law principle of legality. So that's where he said, by the laws of England, every invasion of private property, be it ever so minute, is a trespass. No man can set his foot upon my ground without my license, but he is liable to an action, though the damage be nothing, which is proved by every declaration in the trespass, where the defendant is called upon to answer for bruising the grass and even treading upon the soil. If he admits the fact, he is bound to show by way of justification that some positive law has empowered or excused him. The rule was emphasized by Bingham, MR, in R versus Somerset County Council, Expert Fewings, 1995, 3 ALL ER 20.
Okay. The problem I have, Vivian, with that answer in raising the principle of legality is that arguably the decision of the Commonwealth Development Authority to purchase the property of Greg is actually based on a law, which is the Commonwealth Development Authority Act. So the principle of legality, it's difficult to raise the principle of legality here because the act of the Commonwealth Development Authority is in fact sanctioned by a law passed by the Commonwealth Parliament. So that's the problem there. Now, Edward raised the point, though, that the decision is likely to be valid and it's difficult to oppose it because it wasn't done for an ulterior purpose. And so therefore he was saying that he would advise against opposing CDA's offer to purchase. Does everyone agree with what Edward said?
Well, I think there might be an ulterior motive, but we don't have that information in the question. So,
okay.
Initially it looked like the case that you referred to in the notes. What was the name? Sam Rain Pty Limited. But I think in that case it was quite obvious that there was an ulterior motive and that they intended to make money from the acquisition.
Now, here, Edward, it's clear that there is no ulterior motive, if you call it that, but there seems to be a different motive. We will notice that this particular law said that any purchases was going to be necessary to meet the infrastructure needs for new roads. That is the purpose of the law, we could say. But it would appear that the decision to purchase that particular land belonging to Greg is motivated by a speculative or a purpose towards investment because the CDA believes that the value of the land will appreciate. So in other words, the purchase of the land isn't at this point or at that point necessary for the infrastructure needs for new roads. But the CDA was planning to buy it because the value of the land will go up. So therefore, the purpose appears to be different. The question then is, can the decision of the CDA be attacked? Because it would appear that the decision of the CDA is motivated by a purpose different from that, which appears to be the intent of the law. Not ulterior, but different purpose.
Okay, that wasn't my reading of it because it says he noted that the property is likely to appreciate in value.
Mm-hmm.
So I thought that was sort of more of just a side comment.
Okay, so
it doesn't say in the question that the reason for the acquisition is because the land will go up in value.
Okay, so if we raise that point, that it would appear that there is a different purpose behind the purchase, which in other words, there is really no need for that land to be bought for the infrastructure needs, but it appears that the purchase is motivated by a speculative or an investment purpose. can that be the basis to attack the legality of the administrative decision?
Yes, I think so.
Go ahead. Can you explain that for us, Edward?
No, I can't, because I answered the question on the basis that he wouldn't be able to challenge it, so I haven't really prepared an answer for saying that he would.
Yeah, so here I would argue that the proper answer is that there is a strong legal ground to oppose CDA's offer to purchase, because in the case of Brownells Limited versus Ironmongers Wages Board, the High Court ruled that the exercise of a power for a different or an ulterior purpose would be illegal and invalid. And in this particular case, the purpose of the purchase is not for the infrastructure needs, but it is for a different purpose, which is really about investment or speculation. So following the case of Brownells Limited versus Ironmongers Wages Board, as well as the case of Municipal Council of Sydney versus Campbell, it is necessary that a body must exercise its legislative powers according to the specified purpose under the legislation, and it will not be permitted by the courts to exercise its powers for a different purpose. Okay, moving on to the next question. In fact, if you look at Section 5(2)(c) of the Administrative Decisions Judicial Review Act of 1977 Commonwealth, it provides that an order of review can be sought in respect of an exercise of power for a purpose other than a purpose for which the power is conferred. So that is a ground for judicial review under the ADJR Act of 1977. Discussion question 21. Can I have someone read that question for us? Vivian, can you read the question for us? Please unmute yourself, Vivian.
Yes, please, I'm trying to. Well, I can't see properly from this one. I have to use my laptop, sorry.
Okay.
Okay, so under the discussion question 21, under the National Business Risk Assessment Agency Act 2012 Commonwealth, the National Business Risk Assessment Agency, NBRAA, was created to examine, review, and assess business risks to Australia and provide policy recommendations in the area of business risks to the federal government. The Act also empowered the NBRAA to review its statutory mandate, broaden the scope of its purpose, and make every regulation necessary or convenient to be prescribed for carrying out or giving effect to this Act. In May 2013, the NBRAA Executive Board, concerned about human rights violations and security threats in Afghanistan, Iraq, and Syria, passed the Restricted Commercial and Business Activities Regulations 2013, which imposed huge fines on any Australian business that conducted or engaged in any new business or commercial activity in any of those countries without its prior written authority. The Hotbed Startup Property Limited sought approval from the NBRAA to sell its products in Syria. When the NBRAA refused to give its approval, the company challenged the agency's legal authority to pass the Restricted Commercial and Business Activities Regulations 2013. In its letter to the company, the NBRAA pointed out that under the National Business Risk Assessment Agency Act 2012 Commonwealth, it had broad and unqualified powers to validly pass the contested regulations. Hotbed Startup Property Limited has approached you as a solicitor for advice. Advise the company whether it has a legal ground to challenge the decision of the NBRAA.
Thank you.
Thank you.
What do you think? Any of the three of you?
Okay, so so the question's asking whether the agency has the power to impose these fines, and whether that comes under the powers they've been granted by statute. And I think because the powers seem to be quite broad, and it can review its own statutory mandate and broaden its scope of purpose. So on that basis, they would try and argue that they've extended their scope to include imposing these fines on companies that trade with certain countries. But I think if you looked at the situation, you would I think the scope of their powers would still need to be within the terms of the original statute, and I think it would be found that this was beyond the scope when Parliament legislated on this.
Very good. Why would you say that it seems to be beyond the scope of the law, of the statute?
Because the purpose is relating to business risks to Australia, and dealing with these certain countries wouldn't seem to be a business risk. It's more of a political issue.
Very good. Very good. So there's the correct answer there. So it is. Thank you, Edward. That's the correct answer there. Thank you. So what the argument had been of the NBRAA was that it had broad and unqualified powers to validly pass the contested regulations, because the Act said that the NBRAA has the power to review its statutory mandate and broaden the scope of its purpose, etc. So it seems that that is an umbrella power, an overly broad power that has been vested in the NBRAA by the law. But the High Court, for example, in the case of Shilasky versus Minister for Immigration, has pointed out that even if the authority that has been conferred on a decision maker seems to be expressly unqualified, it doesn't mean that it is in fact unqualified, as pointed out by Edward. Even if the powers vested by the law appears to be very, very general and broad, the interpretation of that law still has to be done in a way that you examine the scope and purpose of the enactment, which is the source of the power of the original decision maker. So as pointed out, so even if the mandate is broad, even if the law is broad, it doesn't mean that the discretion therefore is absolute. It doesn't mean that it is bounded, it's unbounded. The rule of legality requires that there has to be constraints on the power of decision making by the executive. And according to the case of Shilasky versus Minister for Immigration, what it means is that the law must still be read as according to its scope and purpose. And for this reason, as pointed out by Edward, the law provides that it is about the power of NBRAA to examine, review, and assess business risks to Australia. And what the NBRAA has done instead is actually to kind of regulate businesses in Australia and even imposing huge fines. So that seems to be beyond the scope of the law. And for that reason, as pointed out correctly by Edward, there is a strong legal ground to challenge the decision of the NBRAA, because it seems to be exercising a power that is beyond that authorized by the legislation.
Right, so just a question on that. So
Yes.
is the issue that they are issuing fines, which is outside of the scope of their power, or is it that it has a kind of political angle in that it's targeting certain countries?
It could be both. It's actually both. One is the fact that it is imposing huge fines, and two, that it is regulating businesses within Australia. That appears to be beyond the legislative scope, which is simply for the NBRAA to to examine, review, and assess business risks and provide policy recommendations. So in other words, that enabling provision of the Act, which allows the NBRAA to review its statutory mandate, broaden the scope of its purpose, has to be read and delimited by the statutory purpose, which is all about business risks and providing policy recommendations. So in other words, the power by which NBRAA, which has given to itself to impose huge fines as well as to regulate business activity, would appear to be beyond the legislative scope and purpose. Is that okay, Edward?
Yeah, that's great, thanks.
Okay, thank you. Well, we initially had 2 questions, and I thought we just might run out of time, given that oftentimes there's just 2 or 3 students appearing. So I came up with a 3rd question, which is almost similar to the first question, but I just changed the facts a bit. Can somebody read question 21A for us?
Okay. The Commonwealth Development Authority Act, Commonwealth, authorised the Commonwealth Development Authority to compulsorily purchase or acquire any land necessary to meet the infrastructure needs for new roads and highways of the Commonwealth. Under the Act, the CDA, in exercising its powers to compulsorily purchase or acquire any land, must primarily consider the infrastructure needs for new roads and highways of the Commonwealth, as well as other objects that promote the main object of the Act. At the CDA's Executive Committee meeting on the 16th of May 2013, the CDA's Chief Executive Officer proposed the purchase of a sizable property along Benwick Road that was close to an area where a multi-billion-dollar commercial complex was being developed. He noted that the Benwick Road property is likely to appreciate in value as a result of the commercial development going on in the area. The proposal was approved by the CDA Executive Committee. In June 2013, Greg Harrison received a letter from the CDA stating that it was commencing negotiations with him for the purchase and acquisition of his property along Benwick Road, as authorised by the Commonwealth Development Authority Act. Greg does not wish to sell his property and has come to you as a solicitor for advice. He brought with him a copy of the 16th of May 2013 Executive Committee meeting of the CDA, advised Greg whether there are strong legal grounds to oppose CDA's offer to purchase.
Thank you. Thank you, Edward. Let me just point out that what has changed here is that, in the facts, is that under the Act, it now provides that the CDA, in exercising its powers, must primarily consider the infrastructure needs for new roads and highways of the Commonwealth, as well as other objects that promote the main object of the Act. So that is now the change in the law. So that is what has changed in the factual scenario. If you were to be the solicitor for Greg, what would you advise him?
I don't think he has any legal grounds, because you've got there that as well as other objects that promote the main object of the Act. So the main object of the Act is to compulsorily purchase or acquire any land necessary to meet the infrastructure needs for new roads and highways. So that also, maybe when you're investing in property, that might come under the this umbrella of other objects that promote the main object of the Act.
Mm-hmm. Very good, Edward.
Yeah, but do we know what the main object of the Act is?
The main object of the Act would be to consider the infrastructure needs for new roads. It says here, must primarily consider. So that's the main object. Primarily consider the infrastructure needs for new roads and highways of the Commonwealth. And secondarily, as well as other objects that promote the main object of the Act. So what you have is a legislation that seems to have multiple purposes. The main object being which is to consider the infrastructure needs for new roads. and secondary objects, which involve other objects that promote the main object of the Act, which is to consider the infrastructure needs for new roads and highways of the Commonwealth. So what happens in a situation where the action of the executive is motivated by a secondary purpose? So obviously it's not about, just like the first question, factual scenario we had, the main motivation is not really because the land is needed for the infrastructure needs, but the land is bought, but the CDA is planning to purchase the land because of speculation and investment purposes. So the question is, that arguably that can fall under other objects that promote the main object of the Act.
Okay, so how would that be another object that promotes the main object of the Act if they weren't going to use it for road building? I mean, would they argue that, well, if they can make money from it, they can use that money to then improve infrastructure?
That's right. That could be an argument that could be made. What do you think? So the point here is that the legislation actually authorizes multiple purposes. And the rule is, if the executive decision maker makes a decision on the basis of any of those authorized purposes, then the decision maker would be making a decision that is according to the purpose of the Act. And therefore the action of the decision maker would be valid. As pointed out by Edward, it could be argued that whilst the purchase of the land is not necessary at this time, the fact that it could be made for a speculative or an investment purpose means that at some point the CDA will have a financial windfall, and that financial windfall can then help the CDA later on in acquiring new roads and highways of the Commonwealth, which arguably falls within that other purpose of the Act, which is other objects that promote the main object of the Act. So if you frame the argument that way, it is likely the case that there will be no strong legal ground to oppose CDA's offer to purchase. So we make a distinction between an act which authorizes multiple purposes as opposed to an action of a decision maker where there is a purpose and the decision maker is acting on a different purpose not authorized by the Act, because in that case that there will be a ground for an administrative review of the decision. Okay, questions, comments? So that is, if you follow the case of Samrain Proprietary Limited versus Metropolitan Water, Sewerage and Drainage Board, that will be a case where the High Court would actually sanction the decision made by a decision maker for as long as it falls within one of the purposes of an enabling statute. I only have 3 questions for tonight. Are there any questions or issues that you might raise? So earlier I had talked about the case of Dr. Hanif, where at some point, using the powers of the Minister for Immigration to detain a non-Australian citizen for a period of time without any charges against him in court, it was alleged that the actions of the minister were actually for an ulterior purpose. Because at that point, initially, Dr. Hanif had been charged before the magistrate's court, but the charges for abetting terrorism were eventually withdrawn. And what the Minister for Immigration did was then to invoke his power under the Immigration Act to detain a person who does not have a valid visa. And at that point, Dr. Hanif did not have a valid visa because the Minister for Immigration had revoked his visa. So the detention was made for the purpose of eventually expelling him from Australia, which is what the Australian government did. But there was a question as to the motive of the Minister for Immigration in revoking the visa and detaining Dr. Hanif after the charges against him for abetting terrorism had been dropped at the magistrate's court. The problem with this particular factual scenario, which was covered by the High Court in the case of Hanif versus Minister for Immigration, is that not all decisions of the Minister for Immigration can actually come before the Administrative Appeals Tribunal. So we will recall that recourse to the Administrative Appeals Tribunal can only be made if the decision of the decision maker is based on a statute, and that particular statute authorizes an application for review with the AAT. So that one was foreclosed because the AAT did not allow for a review of, under the Immigration Act of 1997. It did not allow for decisions to be made by the Minister of Immigration using his discretion to be reviewed by the AAT. But at the same time, the Migration Act of 1997 contained a privative clause or even an ouster clause where decisions made by the Minister for Immigration in the exercise of his discretion could not be questioned or brought on appeal or reviewed by a court of law. So the question was that particular provision valid, that provision of the law valid, so that it then prevented courts from exercising its power of judicial review over a decision of the Minister for Immigration. So that is both a constitutional law question as well as an administrative law question, because it would appear that the scope of judicial review was foreclosed by the Migration Act itself. So the question is that part of the provision of the law valid? What do you think?
I'm sorry, Manjo, I don't really understand the question. I kind of got lost there. I think it's because it's so long, the question. It's really hard to keep up and understand.
Okay.
I'm just being honest.
Yeah, so I'll simplify the question. So the Migration Act had an ouster clause, a so-called ouster clause, which prevented judicial review to be made by the courts, therefore, of decisions made by the Minister for Immigration when he exercised his discretion. The question is, would that provision, that so-called ouster clause, be valid? And second question is, was there actually scope for judicial review notwithstanding that so-called ouster clause, where it was said that any decision of the Minister for Immigration when he exercised his discretion could not be questioned on appeal or could not be questioned in judicial review proceedings before a court of law? Was there still scope for judicial review? That's a question.
So are you saying that the right for judicial review was ousted?
Mm-hmm. According to the law, according to the
and whether that is valid.
Whether that is valid, and would that mean therefore that the scope for judicial review has now been foreclosed because of the act? In other words, as far as Dr. Hanif was concerned, did it mean that he no longer had any recourse to the courts for them to review the decision of the Minister for Immigration according to that provision of the Migration Act of 1997 Commonwealth?
Well, I would think that's not right.
Go on. Yeah.
Well, all administrative decisions have to have some recourse of where you have to have a pathway of appeal, and you can't just make a law saying that, well, saying that you can't, that, hang on, let me think here. That a decision that the minister has to make, I'm kind of getting lost here, sorry. It's kind of complicated.
You're doing good. Go on.
You're doing good. Go on.
That you can't just stop someone because of their personal circumstances, I guess what I'm trying to say, and you cannot prevent them because all administrative decisions, everyone has a right to have them appealed.
Okay. What's your legal basis for that? Because remember, as far as appeal is concerned, appeal is a matter of statute. It's a matter of what the parliament provides. So if the parliament does not provide for appeal, then there is no scope for appeal. There's nothing in the Constitution that grants individuals the right of appeal. That is a statutory right. So if that right is not provided by the law, then there can be no appeal. But I understand your point in saying, and I agree with you, that in a political society, there should be recourse to the courts for administrative decisions, especially when the administrative decision appears to be unlawful. Unlawful for a variety of reasons. Unlawful, for example, because there might be arbitrary detention involved. Unlawful because it goes against the rule of law. So the question really is, can the decisions of the administrative decision maker be insulated from judicial review? Because that is what the law says. That is the question. So in other words, in particular, in relation to the question of in relation to the circumstances of Dr. Hanif, was the scope for judicial review, therefore, was there no longer any scope for judicial review because, according to the Migration Act of 1977, decisions made by the Minister for Migration under the Migration Act of 1997 in the exercise of discretion could not be brought on appeal or could not be subject to judicial review by the courts. So my question was, would that mean therefore that there is no longer scope for the judicial review because that is what the Migration Act of 1997 Commonwealth said?
Hi, was this not in this week's constitutional law topic?
On the ouster clauses?
Yeah.
Potentially, yes.
Would this not be the case of R and Hickman, ex-party Fox and Clinton?
Go ahead, yeah.
Where an ouster clause is valid, provided that the decision is a bona fide attempt to exercise the power of the board or tribunal, it relates to the subject matter of the legislation, and that is reasonably capable of reference to the power given to the body.
Mm-hmm. Yeah, but okay, so that's good, Edward. But the key point there is an ouster clause actually valid in the sense that can the parliament actually insulate a decision of the executive so that it is not susceptible to judicial review? That is the question there.
Yes.
Vivian, yeah?
I think so, because I read somewhere in one of the notes, one of the weeks, about exclusions. There are exclusions, exceptions for judicial review.
Okay.
There are exceptions.
So,
there are some things that cannot be taken for judicial review. You gave us a list of some of them.
So that is correct. It is possible for the Commonwealth Parliament to delimit the scope of judicial review. But in the case, if you remember the case of A versus Hayden, and we look at the case of Dr. Hanif, and especially in relation to ouster clauses, the power of the High Court, for example, the original jurisdiction of the High Court under Section 75 to issue writs of mandamus, prohibition, or injunction cannot be removed by a legislative enactment, because that is according to the Constitution. So the High Court always has the original jurisdiction in all matters where what is involved is the issuance of writ of mandamus, prohibition, or injunction against an officer of the Commonwealth.
Okay, mandamus.
So that is one. That's Section 75 of the Constitution. The High Court, so that power cannot be removed by the Commonwealth Parliament. It is beyond the scope of the power of the Commonwealth Parliament to remove the power of the High Court. And that is an example of the exercise of judicial review. And secondly, it would be difficult to argue that the Commonwealth Parliament can pass a law so that an action of the executive can be insulated totally from judicial review. A privative clause is permissible because a privative clause delimits the power of judicial review, delimits the scope of judicial review. That can be in terms of whether or not there can be an appeal. That can be a question of what circumstances, what evidence might potentially be reviewed by a court, in what circumstances judicial review might be possible. So those are examples of a privative clause. It just delimits the power of judicial review. But to totally say that the courts are ousted of their jurisdiction to review the legality of an executive decision maker, that would be unconstitutional, because the courts always, both under the Constitution and under common law, have always retained and exercised their power to review the decisions of the executive when they are contrary to law.
Hi, can I just clarify, because this wasn't in the notes for administrative law this week, but it was in the constitutional law notes. Are we being assessed on it in both subjects?
Not the ouster clause, but remember about 2 weeks back, we talked about the A versus Hayden #2. And essentially the question is, can the Commonwealth Parliament insulate the executive decision maker so that his or her decisions are beyond the scope of, totally beyond the scope of judicial review? And the answer is no. That is part of administrative law. That aspect is part of administrative law. It is related to constitutional law. Edward, was that clear?
Oh, yep, that's clear. Thank you.
Yeah, so we took that up, I think, 2 or 3 weeks ago, where an instance, the case of A versus Hayden #2, where the Commonwealth Parliament said that, the Australian Federal Police, for example, could conduct activities, and anything that they did, even if it was against the law, would still be valid. And secondly, that their actions would be beyond the scope of judicial review. And the High Court, in the case of A versus Hayden #2, struck down that legislation for breaching the separation of powers, because it is for the courts ultimately to decide on the constitutionality or the legality of executive actions and decision making, so that it is not legally permissible for the Commonwealth Parliament to pass a law that totally insulates decisions of the executive from judicial review. It can delimit the scope of judicial review, but it cannot totally foreclose judicial review, especially in relation to Section 75 of the Australian Commonwealth Constitution pertaining to the original jurisdiction of the High Court. So that part is administrative law. Okay.
Manjo, what about
Curtis? Yes.
What about the military tribunal we have just been discussing about? Can the courts query their decision of the military tribunal?
Sorry, Edward. Ernest, you're kind of cutting up. I couldn't hear you quite well. What was it again?
What about the military tribunals?
Yes.
Can the court pass the decision of the military tribunal? This is just been discussing.
Sorry, can the courts what?
Can the courts decide on the decisions that have already been done by the tribunal?
Okay. So So there is a problem with your mic, Ernest, but if I hear you correctly, your question was, can the regular courts review decisions of military tribunals? Was that the question?
Yes, yes, yes.
Okay. So military tribunals would be a distinct breed, because in the first place, military tribunals are exercising judicial power, but they seem, in the case of R versus Bevan, they seem to, although they're exercising judicial power of the Commonwealth, they are exercising parts of the Commonwealth outside of the Australian Constitution. And the High Court authorized that as part of historical practice and as part of the operational efficiency of the Australian Defence Force. But the other thing we need to point out is that reviews of decisions by tribunals or of courts, or questions of appeal, are really matters of statute. So there is no constitutional right that that anything is subject to appeal. There is an appeal only if the law passed by Parliament provides for it. So the appeal is different from the question of judicial review, because appeal is both on a question of law and of a fact. But judicial review is focused on a question of law. And the question that arises is, can a decision, for example, made by the military tribunal be brought before the High Court on a question of law? For example, on the basis of judicial review. So that's not an appeal. This is a question of a review of decisions made by the military tribunal brought to the High Court. And I would argue that it is permissible for the High Court to review decisions of military tribunals, exercising its power of judicial review under Section 75, subparagraph 5, where the High Court has an original jurisdiction in all matters involving the issuance of writs of mandamus, prohibition, or injunction against officers of the Commonwealth. And military tribunals fall within the concept of officers of the Commonwealth. But that has to be on a question of law and where the writ of mandamus, prohibition, or injunction is involved. So those are limited remedies there, if you will notice. Okay, any other questions? The other thing was, in my email, I had said that I was going to spend another 15 minutes or so as kind of a drop-in session. If you had any questions about the assessment or about the marks for the research essay or anything about the unit. So we could extend if you wish. So we could still discuss. I'm done with the tutorial. It's now 8:15, so we're done with the tutorial. We've covered 3 questions. You could raise any questions or provide any comments in relation to the tutorial, or raise questions about the midterm assessment, the one which is due, is it next week? Or you could ask questions about administrative law. This is the drop-in session for that. Or questions about your research essay, the marking. So I'm prepared to extend my time tonight to address those questions. Edward?
I had a question about the next assessment.
Yes.
The first 2 questions, so one of them is addressing judicial review and the other one the merits review. Mm-hmm. I was struggling to fit everything into 500 words for each of those parts of the question. So I just wondered, are you expecting us to go through every aspect of saying whether judicial review would apply, for example, or you just want us to focus on like the key bits that might be contentious in that scenario?
So point 1 I wish to make is that students have to make sure that they do not go beyond the word limit. So that's 1. Don't go beyond the word limit, because anything beyond the word limit, I will not be reading and I will not be marking. So having said that, given that there is a strict word count, what students need to do is to make sure that every single word, in fact, counts. Anything they write there in the answer has to count. So what it probably means as well is that students have to be more discerning and more strategic in choosing which concepts or issues or even legal principles that they will discuss in their answers, which might mean that they should probably focus on key points or key concepts instead of doing an enumeration of rules or legal principles. Does that answer the question?
Yes, that's great. Thank you.
Questions? Other questions or comments? Well, I'm going to stay on just in case, and I'm going to stop the recording now because the tutorial is effectively finished.